So, Matt, thanks for joining us or joining me today. Just to let everybody know who's tuning in, Matt and I are going to start having semi-regular discussions about telecommunications, cybersecurity, AI, legal, regulatory matters that are kind of affecting telecommunications carriers, communications carriers, really anybody in the digital marketplace. As some background, I worked with Matt for 2 years do we want to say where we worked, Matt?
A
We
large multinational.
Yes. We worked together. We really enjoyed it. So we decided to continue having the conversation kind of after that. And I'm really looking forward to this. And Matt, thanks for being part of it.
Likewise. Thank you for connecting and getting this going. This is going to be really great. I think obviously, 2 years together working, it was good fun. We we worked pretty much across all kinds of weird and wonderful places and questions. So there's a lot to unpack, which is
Yeah.
which is very cool. So I'm looking forward to doing that.
Oh, absolutely, absolutely. And as we were just talking about, I think this is topical now too, because I think, as you were saying, a lot of the issues that we were discussing as almost theoretical over the past 2 years are really coming to a head. So I think it'll be really good to kind of work through those, especially a lot of the AI and cybersecurity issues. And just to give some context here, I'm I'm in the United States, so I am gonna cover the United States angle of this, and Matt is in Britain, so he's kind of the EU across the pond expert here. So one of the things that I'm really looking forward to is discussing kind of the interplay between, US
Yep.
regulatory law and then kind of EU British regulatory law as well. So I think that's going to be a really, really good discussion as well. So I guess to start off, Matt, tell us some of the kind of interesting developments that are going on in the EU right now. Maybe I know there's the new EU Digital Networks Act that is coming into effect, or has it already come into effect? I'm not sure. So maybe start off with that, and then we can kind of dive into kind of the specifics there.
Yeah. Well, probably at that high level, broad strokes approach, a lot's happening in really broad terms. What I would say for an American audience, maybe for anyone who hasn't sort of been working over here, is familiar with the market. Over the past 10 years, across the big areas of data privacy, say cybersecurity, AI regulation, what you saw was a really big, comprehensive overhaul of the law designed predominantly, I suppose, in response to, the EU's digital strategy. They decided they wanted to update and modernize their laws. A really big sort of like, once every 20 years shift happened.
Mm-hmm.
And that caught everyone by surprise. There's a lot of rapid movement. GDPR is probably the most,
Yeah.
well-known example across the pond because of its extraterritoriality. We saw similar things with NIS2 in cybersecurity. And then obviously you've got the great big the AI Act regulation.
Mm-hmm. Yeah.
That was probably, let's call that the last 4 or 5 years. So an explosion of law, lots of new stuff, lots of new regulation, lots of stuff that everyone has to catch up with. Maybe overshot the mark a little bit. The EU, they're renowned for gold plating, you know, why let, good business get in the way of regulation.
Right.
And I think there's been a tacit acknowledgement of that. So what we've seen in the last couple of years was initially proposals, now through the Digital Omnibus, Digital Networks Act. And actually, it's more towards streamlining, reducing the regulatory burden, because I
Mm.
think that they've realized that there are huge implementation challenges in a place like the EU where you
Mm-hmm.
have, you know, many, many, many member states all taking their spin on it and saying, well, we're
Right.
going to do it this way, this way. A lot of admin burden, a lot of duplication of compliance. So particularly if you're a multinational, particularly for a US client, if you're a US based business that operates across the EU, you're not set up
Mm-hmm.
for that granular sort of regulatory compliance. And I think they've realized that.
Mm-hmm.
So you're seeing with AI, for example, the AI Act, regulatory compliance deadlines for high risk systems have now been pushed
Yeah.
out a year. I
Oh,
think that
wow.
is Yeah, yeah. So I think that they're acknowledging that it is no small challenge to actually do this big uplift, have all these policies and procedures in place, and actively comply. So there's some good news there. It doesn't mean that it's problems gone away.
Yeah.
Actually, the market is getting very busy for that space.
Yeah.
The other area, I suppose, is around telco. So you've got the EU modernized their telco laws. Traditionally, it was 4 directives consolidated down into one. The one
Hmm.
directive was called the European Electronic Communications Code. It was supposed to modernize and streamline the law, and it did to a degree, but it still retained some of that country by country administrative burden because a lot of the things around incident reporting, registration with local authorities, for example,
Right.
demonstration of compliance was still done at the nation state level. What they are trying to do now is move that to a centralized single regulator, so like a main establishment, and say in that main establishment, you will have your primary regulator. If you can satisfy your compliance obligations in that market, you will be taken to comply with your obligations broadly in all markets.
Oh, wow. That's a big shift. That
It's
really
a huge
is.
shift. Yeah. So that is actually really good news. If you're
Yeah.
coming from overseas, the compliance burden hasn't changed. It's still
Right.
pretty onerous. And I think if you're coming from outside of the EU, it might surprise you at just how onerous it is
Hmm.
because
So
it's a
how would,
proactive regime.
yeah, so how would the new regime work? So say I'm a US company and I have offices in Netherlands, France, Germany. Would I have to still register with each of those regulators and comply with the local regulations, or could I just pick, say, Germany, and then I'm compliant everywhere?
I'd have to look into that in a little bit more detail, actually, just to
Yeah.
really pin that down. So that would be a really good topic in its own right to discuss. But basically, what what you're looking at, I guess, is
Yeah.
what's the nexus with your core market? So
Right.
they they sort of apply a similar test in the GDPR, NIS2,
Hmm.
and that is sort of where are your operations centrally
Right.
located, which is actually a surprisingly hard question to answer sometimes.
Oh, absolutely. Absolutely. Especially when you're, you know, have offices in different countries and they do different things in different offices. I think that's one of the things that is definitely a struggle, is kind of pinpointing where you're sent, especially I think if you're located, in the US or another country, figuring out where you're located in the EU is always it can be a head scratcher, obviously.
It's a big one. And,
Yeah.
and that is probably one of the challenges I think they're trying to resolve. Whether it gets there or not, we'll see. I mean, it still has to be
Hmm.
implemented at a national level, but my hope
Yeah.
is that what we'll see in the next 24 months, say, will be a standardization reporting into a central EU body as opposed to a single national body.
Yeah.
That has advantages too. You're not dealing with multiple sets of compliance. You're actually talking to
Right.
one central regulator who has a much better view of the field, so they can actually
Hmm.
do their job much more efficiently than a series of national regulators trying to coordinate.
Yeah.
So it's a sensible move. As to when it gets implemented and how it's implemented, it's still early days. So we'll see how
Hmm.
that goes. Yeah.
Very, very interesting. So, does this affect cybersecurity as well? Because I know obviously we've had some experience with the the EU cybersecurity regime. Will this also kind of streamline some of the cybersecurity regulations?
Look, it's principally directed at telco. So,
Okay.
I mean, the idea is to sort of update, modernize, make more efficient the electronic communications code.
Mm.
There, the same arguments applied there, though, have been applied in the context of NIS2. And they're saying, well, when you look at the way that NIS2 works, this is a cybersecurity directive for anyone who hasn't heard of it. You can do a
Right.
session on it specifically because it does have a very big impact on telco and digital services.
Oh, absolutely.
Um, those services have an unusual test as to where you're regulated based on the concept of a main establishment, which is essentially looking at where is your corporate decision making made, where operational decisions implemented, where are your people. So it's a tiered
Hmm.
test. unlike other cybersecurity where you'll be looking at where is the physical asset that you must secure located. In theory, NIS2 should already have this main establishment test established, and you should
Right.
see coordination between national regulators. But I think you may remember, and I
Mhm.
remember living, it was a very painful experience of trying to explain that to Italian regulators, Irish regulators,
Yeah.
Polish and French. The reality is it hasn't worked super well. It's
Yeah.
not working
Yeah.
particularly well. And I think everyone's realized that. And
Yeah.
so I think the idea that, an entity like ENISA, which is the cybersecurity lead
Mhm.
authority for the EU, will take on more of a monitoring role. It will go from just being an advisor on best practice to actually stepping into the shoes of the watchdog.
Yeah.
And I think they're probably the best. They're the best resource and best position to really do that across all markets.
Yeah. Yeah.
So I expect
Absolutely.
we'll see that. I do expect we'll see that.
Gotcha. Gotcha. And so we talked about the GDPR as well. Is that kind of pulled into a lot of this streamlining? Are there going to be any changes, do you think? Or are we still going to live with it forever?
It's not going anywhere. Look, the
Yeah,
Europeans love the GDPR.
I know.
It's like the NHS in the UK in a funny way. We're very attached to certain institutions, and it's not going to go anywhere because I think the concern around the way that data is being used,
Right.
where it's
Right.
being stored and accessed from, is just going to exponentially grow.
Hmm.
The the biggest area of movement, I would say, was probably the EDPB, which is the European Data Protection Board's ruling about training of AI models on
Mm.
personal data.
Yeah.
And really interestingly, what they said 12 months ago now was essentially if you do not have a lawful basis to process that data, let's
Hmm.
say consent, or it might be a legitimate business interest,
Right.
then not only is the data set contaminated, the model is contaminated. And the EDPB recommends that the entire model should be deleted on that basis. So there's a real risk. There's entities I know operating out of California who are moving fast and nimble, trying to develop these models, maybe don't have the rigor around their data collection practices that are squarely in the EDPB's sites,
Right.
and that has some potentially very significant ramifications for those models in the European market. So data
Wow.
privacy it's not getting simpler. It's not getting less relevant. It's actually going the other way.
Wow. Wow.
Yeah.
So is the issue here then consent of getting kind of consent of people who are or consent of what's being sucked up into the models?
Well, this is where you need to have a good AI data privacy lawyer. I don't know anyone. If you can think of someone, no, it's
You're looking at
someone.
them. Yeah.
It's actually, generally speaking, I would advise clients against relying on consent as
Hmm.
the key
Interesting.
lawful basis. And the reason is because it's very hard. One of the things with consent is it's conditional. So consent
Right.
has to be freely given and it can be withdrawn. If
Hmm.
you build
Hmm.
your entire training set on data that has that conditionality where a user can say, actually, I no longer wish for you to use my data, it's
Yeah.
very hard to extract that. And then there's questions about what do you do with the output that's been iterated from that data? Is that then
Hmm.
contaminated as well? There are other ways to do it. It's not necessarily the end of the world,
Right.
but you still need to think very carefully about how you're collecting and using the data under the GDPR. One of them is legitimate business interests.
Hmm.
That may look a little bit like consent. It's different. It does still have
Hmm.
broad objection rights. So if you are a data subject, you have the right to object to your data being used for a legitimate
Yeah.
business interest. And there's also a balancing test. But the EDPB has said if you're not relying on consent, and sometimes getting consent, documenting it's very difficult, you have this other test that you can rely on. But even if you're going to rely on that test, ultimately what you need to be able to do is, I guess, segregate your data if you need to, ring fence it,
Wow.
have a whole process in the event that, there is an objection raised to your use of the data, and be able to defend why you think your use of the data, on balance of
Hmm.
interests is is appropriate.
You definitely need a good compliance attorney on this.
You do.
So I guess big picture here, and if I'm a U.S. company, what um, what is some good guidance or some general guidance if I want to say operate in Europe, or if I have existing operations in Europe and all of this, what we've been discussing has caught me by surprise. What are some things that I should be on the lookout for? Kind of what are some common practices that I need to be aware of?
The one thing that I consistently tell people, which I think is important to reiterate now, is not to panic. So, you know, it may seem as though there's a huge regulatory burden, and yeah, and it is. It's a large burden. It's prescriptive. You know, there are significant penalties for getting it wrong. At the same time, attacking it with purpose, strategy, incrementally, you know, solving the problem one step at a time is the way to go. There's no need to panic. You know, if you've got a good plan, you've got good legal counsel, understand the market, understand the regulators in those markets, you can identify the priorities and you attack your problem by priority. You go to the stuff that's really important. You know, it might be adequate controls and documentation of those controls, pretty key requirement under all of the EU's regulations. Don't have that, you're going to be in a spot of bother. You can't spin that up quickly. So you need to be thinking about that early and getting that solved. Incident reporting is another one. Having a really good process there. Then you might go on to some of, not peripheral issues, but I would say relatively lesser issues. You know, you need to have training implemented in the organization. It is a requirement, but I would say it's something that you could look to implement after you've got all the other stuff in place.
Yeah.
I'd also say solve for 80%. Obviously, everyone's trying to comply with the law as best they can. The reality is, even with something like the NIS2 directive, even the GDPR or the AI Act, which are actually binding regulations, should apply verbatim in every jurisdiction. You'll get marginal differences around the edges. If you're a global client and you've got a stretch budget and you're trying to find a way to solve all these problems, you can very quickly bog down in cost and time. What I find is actually most successful is to say, well, look, let's look at your business. How do you do this stuff already? Because a lot of people will have compliance structures there. They just don't think of it maybe in the same terminology. And then it's about gap spotting. And you say, all right, we're going to work with what you've got. We can uplift to say this compliance standard. We build a really strong narrative around it, which can be handed to any regulator, sort of, you know, market agnostic. And in most cases, that is going to cover you for a lot of your risk. Now, there'll be outliers where it doesn't, absolutely. Right. And over time, you want to always be refining it, getting better. But you can take what you're applying in the US and you can apply that in Europe and be very successful. So as long as you've got someone who sort of knows both markets, who can talk to what you're doing currently, what you're planning to do in Europe,
right,
you should be fine.
Absolutely. So there's another topic for one of our future sessions, which is compliance. Actually, that's a good question. Do you recommend kind of insourcing compliance in the EU, or are there parts that are better kind of outsourced to a regulatory expert, a law firm, or some other compliance provider?
It's a really good question because it's actually a little bit nuanced. I think what you're
that's
saying.
What we do here.
I will say that if I was trying to describe what the market's doing, I'm seeing a lot of insourcing, you know, into teams. People are trying to use tools like AI to help with compliance. It has a place, and it's certainly not impossible to use AI for compliance, provided that you have your governance in place around the AI. You've got someone like a human in the loop making decisions, or on the loop supervising decisions model. That's probably fine. You can't fully automate, I will say that. And that's caught some people caught them out because they think that they can.
Hmm.
Because it's a continuous activity, I think the traditional law firm model can be very expensive. So you're seeing firms move away from it.
Right.
However,
Right.
if you work with someone who can, I guess, work with like a blended sort of cost structure or can provide you like a fractional
Hmm.
solution, someone who maybe sits to the side virtually is not
Yeah.
exactly in the organization, but is embedded parallel to it or has access to
Hmm.
the teams that operate, that can be effective. There are some situations still in certain EU markets where you do need local counsel.
Interesting. Yeah.
And the main reason there is actually admin, I find, is because these systems for registering as a critical infrastructure operator, reporting incidents, submitting your documentation for audit,
Hmm.
validation with the regulator is set up at a national level. And they
Right.
really, with the exception of some places, the Scandinavians have been pretty good. They haven't done that with global customers or sorry,
Interesting.
global entities in
Yeah.
mind.
Yeah.
So that can be very difficult. You need to sometimes operate through an intermediary in that country.
Hmm.
That's the
Hmm.
kind of thing that I think they're talking about simplifying and standardizing.
Yeah.
So
I remember that was a big issue when we were discussing it, was trying to find local entities
absolutely.
and have someone at the ready in case, a hacker attacked and you need someone in Bosnia or Italy.
I mean, the good thing about, I suppose, the EU model as a reference point, even outside of the EU, really, is
Hmm.
that because they tend to set the gold standard, a lot of other regions will look to them and say, well, let's
Yeah.
draw on this. It's a great model for regulation. So,
Hmm.
I take my home jurisdiction, Australia, we have the Security of Critical Infrastructure Act.
Yep.
SOCI has a lot of parallels to
Yeah.
NIS2.
Yeah.
The,
Yeah.
the UK is bringing out the cybersecurity and resilience bill. We
Mm-hmm.
don't know when it'll land. We've been told it's going to land. Department of Science have said it's on the way, and we
Right.
know some of the themes from it. It'll be a little bit less burdensome
Hmm.
than NIS2, but it will have the same thematic compliance. It'll be proactive. It'll
Hmm.
involve demonstrating controls, having incident reporting,
Yeah.
having
Yeah.
accountable leadership. I bring that up because in some ways it is good news because that consistency
Yes.
means if you're operating across markets,
Yeah.
if you're clever about it, if you work with the right counsel, you can
Hmm.
actually create a compliance plan that more or less can plug and play where you go.
Yeah. Yeah. Now, I've found that in my experience too, especially in a lot of the, South American countries. They'll
Yep,
kind of
100%.
Xerox copy some of the EU
Absolutely.
laws and they'll tweak it a little bit. I think Brazil or Chile have done that where they'll make it have it a little more local flavor, but it's essentially the same obligations, the same kind of framework, which is nice when you are operating on a global scale, or even if you're
Yeah.
going cross border. I find it's somewhat useful you can get familiar with it.
Yeah.
But that being said, yeah, I think you're right that having a good counsel who knows kind of the differences is key here.
Yeah. Absolutely.
Cool. Well, this was very educational. I feel like we just downloaded
Yeah, we
all
really
the
opened
information here.
a can of worms. I
Yeah,
think there's a few
yeah.
topics there I'd love to get into in some more detail. So
Oh, we
maybe over the next
will.
few sessions, we
Well,
actually get into it.
no,
Um,
we would. I mean, we absolutely will. I think we covered one topic on this list, and there's 6, 7, 8. So plus the ones we talked about on this as well. So, Matt, this was our inaugural video,
wow.
but this was really really exciting, and everybody just stay tuned for more. We're gonna be cranking these out.
100%.
Cool. Thank you, everybody.
Cheers, guys.